Hello and good morning. Welcome to the Liberty and Gun Rights Podcast. I believe this is episode 19. Today's Saturday, January the 20th, 2024. And this is, I believe, our first podcast episode for Liberty and Gun Rights Podcast in 2024. This will be one of many. This morning, I have Lance Duncan online. Hello, Lance.
Hey, how are you doing?
Doing pretty good. Lance, I appreciate you taking some time out of your busy schedule to talk with us. And
Absolutely.
I'm looking forward to the information. I think we came up with the title of Forget What You Think You Know About Federal Firearms Laws. And
Yes.
while this podcast is based out of South Carolina, and we focus a lot on state gun laws, and the things that are going on in Columbia and the Senate Judiciary Committee and all that, and the pre-filed bills that are coming up and all that stuff. We can also talk about federal firearms laws because they directly affect what happens in our state capitals. And so, Lance, I'm going to let you have the floor and introduce yourself to our audience, and we can take off with this.
Okay. For those that don't know, I go by Liberty Bibberty. Kind of a funny little name I came up with. But you'll see me on SC Carry sometimes. Those that have been there a long time are obviously pretty familiar with me. As just going by Lance, but I changed that up. Anyway, I'm the county leader for Kershaw County, with SC Carry. I believe that's right, isn't it?
Yes, sir.
Okay, I wanted to make sure I didn't forget anything with that had to go with that because I'm kind of new to this county leader thing too. My background, a little bit about me. I'm a weapons and firearms enthusiast, super strong 2A supporter. Doesn't get any stronger really. And I have about 17 years of legal research behind my belt, or under my belt, so to speak, into the topic area that we're going to be discussing today. I know that sounds like a lot. Well, many years ago, I discovered that the federal government was not being, I don't really know the word to look for, forthcoming with how they are writing their laws. And so I started researching into that area. And I was right. And it's really scary how right I was, because as you'll discover as we move on, it's not just firearms laws they're telling lies on, but we'll get into that later. So anyway, that's enough about me personally. I think I'll throw it back to you.
All right, Lance. We can go ahead and just dig into your some of your research about federal firearms laws, and I want to, my hope is to provide the listening audience with information that they can easily digest and take notes on, and as they are reaching out to their representatives in Columbia, South Carolina, the House of Representatives and the Senate and all of that, when they're talking to them about what their preference is for how they're going to vote on some of these pre-filed bills, and they're always trying to cram the red flag laws down our throat, and other assorted and sundry Second Amendment related laws they're trying to slowly but surely strip what little rights that we have away from us.
Right.
And so that's my goal for these podcast episodes, is to provide some meat for them to be able to take away, and possibly for them to hear things that they don't normally hear on other more prolific Second Amendment and liberty or gun rights podcasts that are out there. There's a whole smorgasbord of podcasts for people to listen to. So I'm hoping to give them something that they can go, hey, I'm glad we listened to that episode today because they talked about something we needed to know about, and something that we haven't necessarily heard at that level, right?
Absolutely.
So anyway, feel free to just jump in there and give us a foundation of what you're going to be talking about, and then delve into the different things that you've told me about.
Okay. Well, I guess the best way to do this is let's go back to 1934. The original so-called federal act, the first one was 1934. There's one in 38 too. We'll get to that in a minute. 34. They wanted to so-called assist the states, the federal government, by the way. They wanted to assist the states in combating ordinary crime on the streets, which, by the way, there's nothing in the Constitution that allows them to do that. We'll go ahead and put that out there. They wanted to do that. So in 34, they came together and they created the National Firearms Act. What's interesting about that is if you go back and read the original testimony that they were doing on the floor there, you can read through it. It's you can Google it and look it up, and I encourage you to do so, but just be aware it's like 100 and something. I think it's 128 pages. Which seems like a lot, but a lot of it's flim flam, so you can kind of just brush through it. But anyway, when you're reading it, what's interesting is there's a lot of constitutional questioning going on between the different reps and stuff. And even the attorney general at that time is saying that they don't have the constitutional police powers to do a lot of the things that they were inferring they wanted to do with that act. And
I've actually got that up on my screen. I got National Firearms Act of 1934.
Yeah. So the AG says that in there, and then they have another attorney later on toward the end of the segment, and you can actually read this for yourself. He actually says, you are attempting to sidestep the Constitution with what you're doing. Because what they were wanting to do was things like banning pistols for people altogether. They were wanting to do registration. What's something else they wanted to do? Oh, yeah. They wanted to ban manufacturers from even making machine guns at all and selling them. And I think he was a constitutional attorney. He straight up said, you cannot do that. You cannot do that. I mean, he flat out told him that. So it's interesting to see what was going on back there with that commentary. So they passed that act, but it really didn't do a whole lot. I mean, it put a tax on certain items, obviously machine guns. And after that was passed, the 38 Act was passed. There's really not a lot of commentary, so to speak, on the 38 Act. You can kind of look for it. You might find a little bit. Most of that commentary was the 34 Act. But if you notice, too, the 38 Act really didn't do a whole lot as far as if you compare it to the 68 Act, which we'll get to in a minute. So the 38 Act, what it did was it basically dealt with dealers and manufacturers. And outside of that, there wasn't really a whole lot that it did. I mean, you could even still pretty much order a machine gun under the 38 Act, as long as you had done it through a dealer. And in certain states that you had to have a license to, like a permit to purchase. it was mandatory that you had to let the dealer know and show them that permit. But in other states, which it was the majority didn't require that, even at that time, you were good to go. So for 30 years, that act until 1968 stayed the same. Nothing changed. And people wonder why. And the reason, which you'll discover here soon, is that they didn't have the jurisdiction to give them the police powers to do anything more. And they knew it. They flat out knew it. And so what they did was, in the 34 and 38 acts, you can look at the transcript, so to speak, to where they've written out the definition for interstate commerce. And it's a very ambiguously written way that they did that. They did that on purpose. And it's because one of the canons of statutory construction, there's something called constitutional avoidance. And it's a doctrine that where if a statute is questioned constitutionally, and there can be two or more interpretations, and one of those interpretations allows the court to construe something constitutionally versus unconstitutionally, then the court will generally favor the constitutional interpretation in order to kind of circumvent creating a constitutional crisis, so to speak. So that's why they did that. Well, if you go, and that was challenged, those of you obviously are familiar with the Miller case. That was not a challenge directly to the Interstate Commerce Authority. That was just a challenge under the Second Amendment. But what they did was, it was presumed that they had this authority under the Commerce Clause, which they didn't. Even to do the things that they were doing then, they still didn't, which is why they wrote it that way. And then the 68 Act came in, and in 68, some very interesting things happened. In 68, they wrote that act, and it was far more broad with its police power implementation, so to speak, about what they put in there. So what changed? Well, I can tell you what changed. What changed is that they wrote the statutes, they wrote the jurisdictional statute for the Gun Control Act and subsequent NFA in there. They wrote it under what's called geographic territorial jurisdiction. And the way that they did that was, see, the Constitution, it allows Congress two types of jurisdiction. They've either got jurisdiction under subject matter jurisdiction or geographic. Subject matter jurisdiction is things that is the part of the Constitution that gives them, it's expressly granted to them. Things like establishing a post office, things like that. You can kind of go through there and look at it under Article 1, Section 8. Different things. But you'll notice in there, in under that jurisdiction, the only thing that even remotely allows them to touch firearms is Article 1, Section 8, Clause 16. And that is the militia clause. And even then, all they can do is arm the militia of the several states. Now, it doesn't say anything about disarming. They can't. In constitutional law, there's a doctrine. I'm not going to get into all that, but it's a doctrine that says when the Constitution confers a positive reinforcement for Congress to do something, it automatically puts a negative on them being able to do the opposite. So they can arm the militia of the several states, but other than that, they have no authority over firearms. And they knew that then, and so that's why they wrote it under geographic jurisdiction. Geographic jurisdiction is Article 1, Section 8, Clause 17, and Article 4, Section 3, Clause 2. Those two provisions in the Constitution is what gives Congress authority under their geographic jurisdiction. And that's what they've done. They wrote the statute under 18 USC 921A2. They wrote it under a geographic jurisdictional form of interstate commerce. It has nothing to do with the Commerce Clause in the Constitution. And so the reason that they did that is because in geographic jurisdiction, when Congress is legislating for their territories and possessions, they have very broad police powers that they wouldn't otherwise have if legislating in the 50 states of the Union. And this is not just me saying this. It's not like I made this up. The Supreme Court has confirmed this more than once. And James, I don't know if you got that, the court case that I cited to you. I don't know if you have that up, do you?
I've got the notes that you gave me, yeah.
Okay, it should be in there. The case of the Hooven case?
You're talking about Article 1, Section 8, Clause 17?
Yeah, Hooven and Allison Co. There should be the court case in there. Keep going down.
Can you see my screen?
Yeah.
Okay.
Keep going down.
Okay.
Because see, I don't have mine up. That's it right there. That's it. There's the court case right there. And you can kind of read that.
Well, this one right here, Dooley versus United States.
No, go down. Well, it starts right there. The case is Hooven and Allison Co. But keep going back up. Right there. Go down again. Yep. It is no longer doubted that the United States may acquire territory by conquest or treaty and govern it through the exercise of the power of Congress conferred by Section 3 of Article 4 of the Constitution to dispose of and make all needful rules and regulations. All right, scroll down. Respecting the territory and other property belonging to the United States. In exercising this power, Congress is not subject to the same constitutional limitations as when it is legislating for the United States. The term United States may be used in any of several senses. It may be merely the name of a sovereign occupying the position analogous to that of other sovereigns in the family of nations. It may designate the territory over which the sovereignty of the United States extends. That's what we're talking about here. That's that third area. So there you go. There you have it. The Supreme Court has confirmed that. So, and you can go back and look through that whole court case. I encourage you to do so. That case actually translates all the way back to another case called Downs versus Bidwell from 1901. So this understanding of all this has been around for a long time. It's not like this is something new. So when Congress doesn't have any police powers like that, they had to figure out another way to write the laws, and they wrote them under territorial jurisdiction. But they did so in a very, very deceptive way. And if you don't know how to spot what they did there, you'll never see it, because they wrote it in a way so that the average layman cannot understand it. And the way that they did that is, if you look at 18 USC 921A2, you'll notice some interesting things there. But before we get to that, you should know that the provision in Title 18 that actually does deal directly with the Commerce Clause in the Constitution is Section 10. Section 10 of Title 18 does. And that is the general provision. So Section 10, if you scroll through that, it talks about commerce between one state and another state or possession or territory. So it uses very specific language there. That language is very broad, and it applies all throughout Title 18. But, and this is a really big but, when you get to a section where Congress has specifically taken its time to define something like interstate commerce in their own special way, we can no longer look at that general provision. We have to look exactly and precisely to how they've defined it specifically for a special area or act. And the way that they've done that in 921A2 is that they have essentially redefined the word state. So if you look at, I don't know if you can pull, do you have 921A2 pulled up there?
I'm trying to follow. I'm not doing a good job of it, I don't think.
All right. You were, let's see where you're at. All right, go down. Slow it down a little bit. There you go. All right. The term interstate or foreign commerce includes commerce between any place in a state and any place outside of that state, or within any possession of the United States, not including the Canal Zone or the District of Columbia. But such term does not include commerce between places within the same state, but through any place outside of that state. The term state includes the District of Columbia, the Commonwealth of Puerto Rico, and the possessions of the United States. All right. So if you look at that definition, you notice how they've defined the word state and given it a special meaning that it was not given in Section 10. In Section 10, they don't define state. So when they don't define something, one of the canons of construction is that we have to look at the ordinary plain English meaning. The Supreme Court has confirmed this as well. So if anybody's wondering, all of this stuff he's got on here to look at. But anyway, so when we give that its own plain meaning, so far so good for Section 10. But when you get down there and you see how they've redefined state specifically for Chapter 44, you notice that they put the word includes in front of when they start defining state. So it says the term state includes the District of Columbia, the Commonwealth of Puerto Rico, and the possessions. Well, includes, contrary to what most people would think, does not mean that those things also somehow embrace blanketly everywhere else in the United States. Absolutely not. Includes is what is referred to as a term of limited expansion. And what that means is it allows for an enlargement, but it cannot be enlarged and extended to anything else other than the class of things defined after it. So when you see something like that, a definition like that Congress has written, and it's got the definitions two or more items or things, and the word includes goes right in front of it, that is telling you that whatever is defined there it can be enlarged to embrace other things, but only within that special class. So if we look at that special class there, what is it? Well, that is clearly not the 50 states of the Union. That is possessions and territories that it's talking about there. So if you look at that, not only did they redefine state, but they wrote it just a totally different way. And so it says includes commerce between any place in a state and any place outside that state. Well, you see includes right there at the beginning again. Well, the first time, actually, it's right there at the beginning. And after includes comes two or more, a class of two or more things, which is, in this case, it's defining a special class or type of commerce going on there. And that is specific solely to territories and possessions. So anything that's not specifically mentioned there, but can also be within that same class, is also included, but it cannot go any further than that. Does that make sense?
Somewhat.
And I don't know if you've got, yeah, you've got it right there. You've got it where the Supreme Court, well, you got the ruling in Helvering, I think it was. Yes. Yes. So, and then there's the ruling from Helvering, there's the First Circuit ruling from 98, and then there's a Treasury decision also that you can follow. Treasury decisions, just for anybody who doesn't know, they're not actually law, but what they are is they are the authoritative mechanism for which the Secretary of Treasury of the United States delegates, what's the word I'm looking for? Delegate rulemaking authority, kind of, so to speak, with different various things for their executive agencies. So Treasury decisions are only issued, as you can imagine, after significant legal review to be issued. So that's why they do carry significant weight when they are used to, they actually are often used by the courts to interpret sometimes ambiguous statutes. They'll, especially with taxing stuff, obviously, they'll actually look to Treasury decisions sometimes to try to get a clarification of a meaning of certain things. And they did it then, and I believe it's Treasury decision 3980. I think it was 1927. So, I mean, this is not new. This is not rocket science. This stuff has been around for a long time, is my point. And they've been doing this for a really long time. So when you look at how they wrote that statute, if you understand what they did there, the reason that they did it obviously is police powers, because as written, it's completely constitutional as written. It's the misapplication by the executive branch with all this that is unconstitutional. So I don't know if you've got it. I know I put it in there. What's funny about this, the corresponding regulations for Title 18, Chapter 44, the corresponding regulations are 27 CFR 478.11 and 479.11. If you go to those regulations, the first thing that pops up literally is going to be how they define includes and including. I mean, it's the first thing that pops up. If you pull it up, you can go on Law Cornell, whatever you want, and it says right there, the terms includes and including do not exclude other things not enumerated, which are in the same general class or scope. So what that's telling you is, if it doesn't fall within the class or scope of what has been defined, then it cannot be included and is therefore excluded. So, I mean, the regulations are telling you what I'm telling you right now. You don't even need to look at the court cases if you don't want to. Just look at the regulations.
So, Lance, so for the listening audience, which I'm assuming is going to be primarily mostly South Carolina residents, and I could be wrong about that. There might be subscribers from other areas in the United States. How do these things directly affect our state gun laws?
Oh, significantly, because what happens is a lot of state gun laws, as you've seen, a lot of state gun laws will dovetail and be written off of the way that they've got things written in the federal law. For example, like how they define firearm, how they define various definitions of things, machine gun, all of that stuff, they write it basically in tandem with what the federal law says. And the funny thing with that is, if they really knew what was going on here, they would just be like, why are we wasted all this legislation on this? There was no point in even doing this. And that's what gets me. I don't want to sidestep too much, but that's what gets me about. I'm sure you've probably seen these, the case out of Texas, where there's currently in the courts where they're doing the Texas freedom lawsuits or whatever. I don't know if you've heard of that, where Texas has wrote the statutes to kind of circumvent interstate commerce under 921A2. And I'm sitting there thinking, why did they do that? These attorneys know exactly what I'm telling you today. Make no mistake about that. There is no way that they don't. And so they're avoiding this whole thing on purpose. Nobody wants to talk about what's really going on here. And some speculate that it's because they don't want to create a massive constitutional conundrum. Others say that it's because, and I actually firmly believe the first one, and I believe this one, I believe that the gun rights organization, 2A attorneys, they know this stuff. They have no interest in challenging it this way, because if they did, they would lose tens of millions of dollars from litigation with all this stuff. I mean, you can't, I'm sorry, I just don't believe it. You can't convince me that these well-established attorneys from Harvard and wherever else haven't seen and know exactly what I'm telling you today. I mean, this is not stuff that's just come out of a magic hat. And the judges and Supreme Court justices, they're fully aware of it. They know. But their position is that unless the issue is properly raised in court, they're not going to raise it. That's not the way courts work, first of all. They don't make your arguments for you. But besides that, they treat it just as if it was the ordinary commerce clause. So if the issue is never raised, that's how they're going to treat it. And that's why people have seen over the years everyone's saying, oh, well, the courts have allowed Congress to expand the commerce clause way beyond what it's supposed to. No, that's not what's really happened. What's really happened is they've written a ton of laws under this same premise that I'm telling you here today, and it's never challenged under the territorial jurisdiction or lack thereof, never challenged, and so they rule it under the Commerce Clause, and it gets jurisdiction gets expanded. That's what's really happened. So I just want to be clear about that. This is not something that is specific strictly to federal firearms laws. If you look at how they define the term state and United States in various federal laws, you'll see that they've done it the exact same way. And I've actually given you, I think I gave you actually several examples of how they've done that. Let's see, scroll down. There you go, the term state. Okay, that's 921A2. Keep scrolling down. Here we go. All right, stop right there. Okay. An example would be Title 15 USC 1172, Transportation and Gambling Devices. The term state includes the District of Columbia, Puerto Rico, the Virgin Islands, and Guam. 18 USC Section 842. This is commerce and explosives and interstate commerce. If you look at the definition there, well, it's kind of lengthy, but the term state includes the District of Columbia, Commonwealth of Puerto Rico. It's the same thing, but what's interesting there is you notice it when it defines interstate or foreign commerce, it says means commerce. It starts off interstate or foreign commerce means commerce between any place in a state and any place outside of that state. Well, that language sounds similar with one important distinction, and they use the word means instead of includes there at the beginning. Whenever you see means instead of includes used, in other words, when they put means in front of a class of items, two or more things, what that signifies is that is the totality of what is there. Nothing else can be added or taken away from it. So what you see is what you get there, versus includes, which is a term of limited enlargement. And so I just wanted to point that out. But you keep going down the list and you see 26 USC 3121 E1. That's the FICA tax. Yeah, you're reading that right. That doesn't tell you something. The term state includes the District of Columbia, the Commonwealth of Puerto Rico, the Virgin Islands, and American Samoa. Now, if you contrast that, scroll up a little bit. Hold on. Go up a little bit more. Keep going. No, I mean down. I'm sorry. I'm confusing you. I'm throwing curveballs at you. All right, stop right there. So when Congress wants to embrace the 50 states in a statute, they do it. 26 USC 6103 B5A I, examination of forms. This is a taxing statute. State is defined. Any of the 50 states, the District of Columbia, the Commonwealth of Puerto Rico, and so on. 49 United States Code, Commerce and Motor Carriers, Freight Carriers, Section 13102, subsection 21. The term state means the 50 states of the United States and the District of Columbia. So you see how the contrast here of the way that they do this. This is not an oopsie. This does not just, someone might be like, oh, well, they might have just wrote it. No, it doesn't work that way. That is not the way it works. And frankly, when Congress writes legislation, well, I say Congress, the attorneys who are legislative drafters, because Congress doesn't really write the statutes anyway. They have attorneys do it. So I just want to be clear there. But when they do that stuff, none of this stuff happens as an oopsie. They don't just decide, oh, we're going to write it this way today, or we're going to write it that way tomorrow. No. Every word has purpose. And so because the jurisdiction of Congress is so limited under their subject matter jurisdiction, essentially their default jurisdiction is geographic jurisdiction. So anytime you see state defined, and it doesn't say anything about the 50 states, it's talking about geographic jurisdiction. So a lot of times you'll see it say state of the United States. Anytime it says that, that is not talking about the 50 states. I just want to be clear there. So seeing the 50 states in there, that's actually pretty rare to see it. But I wanted to give you some examples in there of that. Scroll down a little bit, James.
Okay.
Hang on, go back up a little bit. Yeah. Hold on. Yeah. 26 USC section 4612 A4, tax on petroleum. The term United States means the 50 states, the District of Columbia, the Commonwealth of Puerto Rico. See, and you have to watch how they define United States too, because remember in the case earlier I mentioned, the Hooven case, they said there's 3 different ways that United States can be defined under federal law. And one of those is territories and possessions. And so I just wanted to point that out there. So you have to look at how they define state and United States, and you kind of have to read them together, but that's how you can spot what's really going on there. Scroll down a little bit. All right, stop right there. 49 USC, interstate railway transportation. State means a state of the United States in the District of Columbia. See, this is what we we're just talking about. 26 USC 3121 E2. This is also deals with FICA tax. This is the definition of United States in there. United States, when used in a geographical sense, includes, there's that word again, the Commonwealth of Puerto Rico, the Virgin Islands, Guam, and American Samoa. So that's showing you the contrast there. If you go down here, the 27 CFR 478, remember the 478 and 479 are the implementing regulations for the Gun Control Act and NFA. So they define state, a state of the United States. The term shall include, there's that word again, the District of Columbia, the Commonwealth of Puerto Rico, and the possessions of the United States. And it must be that way for those regs, because when they say shall is mandatory language. So what that means is when it says shall like that, that is a command to do something. So when they're saying shall include, that's what they're telling you. It has to be this way, is all that means. But even in the regulations, they're defining it that way. Scroll down a little bit. Here we go. United States, for the same 27 CFR 47811 and 47911. United States, the several states and territories in the District of Columbia. State includes the territory. Scroll up a little bit, because you're a little. There you go. State includes a territory in the District of Columbia, and the term territory means the Commonwealth of Puerto Rico. When they say the several states, they're talking about when they put a plural on it, it carries the same meaning as a singular. I just want to put that out there. So the several states is just another way for them to try to confuse you. But it's defining, because they've defined state the same way here. So I just want to point that out.
My computer is it's taking over. Oh my God. Oh, let's see. Let me see if I can move this. I'm gonna stop screen sharing for a second while that's doing whatever it's doing.
Okay. And there was one right below that, under alcohol labeling content. That's 27 CFR 5.1. They're very clear there. And when they define states, it says any one of the 50 states of the United States. So I put that in there to show you they're very aware of what they're doing there. And for good reason. And it's because the regulations, although they cannot expand beyond the statutes authority, they have to comport with it. So they have to write the regulations to be directly in sync, so to speak, with what's written there in the statutes.
All right, let's back up.
Yeah.
Also, we've got about 9 minutes too. So
Okay.
just so you're aware of it.
Yeah. What I'll do is I don't want to go any further right now. I'm gonna turn it back to you, and you can kind of ask me some questions for the next few minutes. Because if we go any further, I'm gonna get to a point where I'm not gonna be able to finish explaining what I'm continuing to get at. So I feel it's important just to do it that way.
Yeah, that's fine. Like I said earlier, if you're some of our listening audience, maybe a little, they may be asking the question, well, that's all fine and good. And we see you're showing us how the legislative branch or the attorneys are using language that is providing Congress or providing the federal government with the control that they're looking for over federal gun laws. I guess if I'm understanding that correctly.
Right. So that's what they're doing there. And why does it pertain? So you may be asking, what? Okay, you've shown us what they're doing there. Well, it has everything to do with what we're taught, what's going on right now. This whole thing is important to understand because we've got it pretty decent right now as far as the Supreme Court goes. But let something happen. And I know nobody wants to think about this, but you have to. Let something happen and let somehow that court get packed with liberal justices and watch what's going to happen. And I can tell you right now, one of the first things they're going to do is try to go after Bruin. And anybody who doesn't believe that has lost their mind because they cannot stand Bruin. Bruin is the absolute epitome of the end of the world for them. So you can bet your butt that they're going to they will write an insane amount of gun laws to ram down our throats if they can get a chance to. They're just waiting for the chance. And I know nobody wants to think about that, but what I'm telling you today, I'm telling you that so that you understand what they've done here. They don't have the jurisdiction. They do not have the jurisdiction. I'm going to repeat that again for you, to do it any other way. Doing it under the ordinary commerce clause in the Constitution will not work. There are too many constitutional roadblocks that would stop them to do it that way. I know some may think, oh, well, if it's struck down this way, they'll just write it under the commerce clause. No. They would not be able to do that. Everything that Congress does happens for a reason. Nothing is an oopsie, so to speak.
Right.
And these people in Congress, they're fully aware of what's going on. All of them. They know. I might give a little bit of benefit of a doubt to like the newbies in Congress who've only been there for like a year or two. But when they've been in there longer than that, they know exactly what's going on. And that's what kills me. It's funny and it's sad at the same time whenever they start talking about gun control at the congressional level. Because I'm just like, yeah, okay.
There's that wonderful term, gun control.
Yeah. What's the second word there? Control. That's what it's really all about anyway.
Right. That takes us all the way back to the Jim Crow era, right?
Oh, yeah. Sure. And I mean, they didn't even start anything at the federal level until, well, with gun control until 34. I mean, they had an excise tax on firearms in 1919, which we can get into that on the next episode if you'd like.
Sure.
Because that's also tied into the excise tax. Well, the jurisdiction is tied in the same with the excise tax on NFA items, but that's a broad category. We'll have to do that obviously later on.
Right. Well, like I said, I'm hoping that as you're illuminating these things for the listening audience, and for me, it's been a very educational thing for me for sure. It's good that that you're showing us what's really going on in the background, and hopefully it'll help us to understand more when our state legislators start copying or using that as a template for the new laws they're trying to pass. Well, we got 3 minutes and 47 seconds, so I'm gonna go ahead and end this. And for our listening audience, I appreciate you taking time out to listen to all of this, and we'll try to explain it more. We're going to try to follow the keep it simple, stupid principle, so that we can understand what's being said and what's going on with federal gun laws and such. And so, with having said that, I want to say thank you for the privilege of your time. Our podcast is hosted on Amazon Music, iHeartRadio, and Spotify. Be sure to share our podcast with your Second Amendment friends, family, and coworkers. You can contact us at Liberty Gun Rights Podcast at proton.me. That's Liberty Gun Rights Podcast at proton.me. Thank you for listening to today's episode. And Lance, thank you for being our guest speaker. And everybody have a good day. And we'll say goodbye for now.
All right.